The email says, service disruption, immediate network maintenance. All right, so here's my question. And I think that group is so great. They're not the ones who decided on this odyssey, but they're starting the service disruption today immediately. So I don't know if they decided just we're going to do maintenance today, or if there was an issue, then it's, hey, we have to do maintenance. Who knows? Oh, okay, thank you. Thank you, Christine.
No problem.
All right, the court is calling 2024 CR 006824 State versus Marco Antonio Moreno. Can I have parties announce?
Ashley Jones for the state. Christine Brown on behalf of Marco Antonio Moreno.
And are you Mr. Moreno?
Yes, ma'am.
All right, you entered a plea in this case to count one of no contest on May 27th. According to your plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. The state is opposed to your application, and there's restitution. I'm sorry, and there's registration and no contact with the complainant. And there was a PSI that was completed in this case. Have both parties had a chance to review the PSI report?
Yes.
Any objections?
The defense objects on page 3 where restitution is discussed. If you were to look at the plea bargain paperwork, restitution was never something that was brought forward by the state. It was not a term of the agreement. There has also been some concern as to the documentation supporting what is proposed as $4,000 as restitution for certain medical expenses. And I have been in communication with probation officer Gloria Medina yesterday morning, who called me telling me that no documentation was provided to her to substantiate that restitution amount. Yesterday, I filed a motion requesting a restitution hearing. As we all know, Odyssey is down and so is e-filing, so it has yet to be accepted. But that is something that we are requesting if that is something that this court still wants to consider.
All right, well, unless the court receives adequate documentation of restitution, then there's not going to be restitution. So state, do you have any itemized billing?
Your Honor, I have not had a chance to speak with our witnesses regarding the restitution. As defense counsel said, I didn't get the motion for
All right.
restitution.
So if both
I
parties,
just served you, but I understand it has yet to be
Right.
accepted by the court.
all right, so if both parties are in agreement, we can go forward with the PSI, and with regards to restitution, that can be determined at a later date if there is any restitution.
Yes, Your Honor.
Are both parties in agreement with that?
Yes, we're in agreement.
All right, so the state is opposed. State, do you have any witnesses?
Your Honor, no, we do not have any witnesses, just arguing.
All right, defense, do you have any witnesses?
Yes, we would like to call Stephen Thorne.
All right, Mr. Thorne is by Zoom. Any objection to the witness appearing by Zoom?
Not the state, Your Honor.
And I know you have no objection, counsel, correct?
No. No
And Mr.
objections.
Marino, do you have any objection to the
No.
witness appearing by Zoom?
No, ma'am.
All right, Mr. Thorne, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Dr. Stephen Thorne.
All right, you may proceed.
All right. Dr. Thorne, my apologies for addressing you with Mr. Pryor.
Oh, that's okay.
Could you please state your profession for the record?
I'm a licensed psychologist in the state of Texas.
And circling back to your profession as a licensed psychologist, where is your place of employment?
I work in a lot of different areas across Texas and other states, but my office is in Austin, Texas.
And so are you self-employed?
Yes, ma'am. I'm in private practice.
And how long have you been in private practice?
I think this August, I think next month will be 23 years, I believe.
And how long have you been a licensed psychologist in the state of Texas?
That same amount. I think in August it'll be 23 years. So,
Are there other states in which you have licensing?
Not full-time, like to a lot of states, if I go testify in those states, I'll have to have like a temporary license. So at any point in time, I may have like temporary license in a couple of different states just when I go testify there, but not full-time.
And what is the extent of the education and training received to obtain your credentials?
I have a bachelor's degree in psychology from Austin College in Sherman, Texas, just about an hour north of Dallas. And I have a PhD in clinical psychology from the University of Texas Southwestern Medical Center at Dallas.
And are these specialized degrees?
Yes, ma'am. I mean, the undergraduate degree is just a general psychology degree, but yes, the doctoral degree is in clinical psychology.
And Dr. Thorne, could you please briefly describe the subject matter of your specialty?
Probably at least 95% or more of my practice is forensic in nature, meaning I do evaluations, consulting, testimony, and legal cases. I testify for, the state. I testify for defense attorneys. I do work at the request of judges and probation departments. I do work for the Texas Department of Criminal Justice. So I kind of do evaluations or consulting or testimony for different parties in the legal system. And I do a few other things that don't involve the courts, but the large majority of what I do in some way involves the legal system.
And you mentioned evaluations. Could you specifically mention what kinds and the proportion of being used?
Most of my evaluations are related to sex offenses, either a risk assessment for sentencing purposes, or I do a lot of what they call the civil commitment of sexually violent predator evaluations as well. I also do things like competency and sanity and adult certification, child custody, family law evaluations. But if there's one area that most of my evaluations and testimony is in, it's in sex-related evaluations.
All right, so just to be clear, a topic of your specialty would include sex offender risk assessment?
Yes, ma'am.
And so have you conducted personal examinations or testing of alleged or convicted sex offenders?
I couldn't hear the last part of that. Of what?
Alleged or convicted sex offenders.
Oh, sure. Yes, ma'am.
And how many of these tests, if you can provide a number more or less, how many of these tests or examinations were conducted by yours?
I mean, over 1,000, maybe 1,500, 2,000, I'll say 1,500 just be an estimate.
And you mentioned that this was your specialty. Do you teach or lecture in the field of sex offender risk assessment?
Yeah, not teach per se, but yes, I speak at forensic conferences for probation officers, mental health professionals, attorneys, judges, about a number of different forensic topics, including, sexual risk assessments.
And so what publications have you authored in this field of sex offender risk assessment?
I don't do a ton of writing, but I haven't published anything specific to sexual recidivism. My publications in journal articles or book chapters have been about antisocial personality disorder and psychopathy.
And is that an aspect that you test for when you conduct these risk assessments?
Sure, particularly antisocial personality disorder is one of or antisocial traits in general is one of the primary risk factors we look at in these types of cases.
And Dr. Thorne, I know that you're virtually testifying today. I have sent you what has been pre-marked as Defendant's Exhibit 1, and I did tender a copy of that proposed exhibit to the state for inspection.
Okay.
And without telling me what it is, do you recognize it?
Is one, I believe, is a copy of the report I wrote in this case, or is one my CV? I can't.
There were two attachments.
Yeah, I'm sorry. I'm trying to pull that up. Exhibit 1 is my CV. So this is a copy of kind of our resume, our curriculum vitae.
And is this a fair and accurate depiction of your curriculum vitae or CV?
Yes, ma'am, it appears to be.
At this time, we are offering into evidence defendant's exhibit 1, the curriculum vitae of Dr. Stephen Thorne.
I would say you just object on Thursday, one, he's here to testify. about
All right.
clarifications.
If I could, and your objection to is what?
Just Thursday, Your Honor.
All right, that objection will be overruled. Defense exhibit number 1 will be admitted.
And Your Honor, pursuant to the Rule 702 of the Texas Rules of Evidence, I am tendering Dr. Stephen Thorne as a qualified expert witness in the field of sex offender risk assessment.
He doesn't have an objection.
All right, then that will be granted, and the court will note that he's an expert in the field.
Thank you, Judge. Dr. Thorne, are you familiar with the specific risk assessment tools used in this particular case?
Yes, ma'am.
And how does this particular risk assessment work as it pertains to Mr. Moreno?
Well, they allow us to kind of collect information relating to risk factors. Like, I'll try to give a short answer, but in doing a risk assessment, we look at, are there any factors that the research suggests can increase an individual's risk for sexual recidivism or decrease an individual's risk for sexual recidivism? And so like the RSVP and the static 99R, those are two different factors or two different assessment measures that kind of help organize those risk factors and protective factors so that we can apply them to the person we're evaluating, in this case being Mr. Moreno.
And so are these forms of assessments accepted as reliable in the scientific community?
Sure. I mean, these are assessment measures that I use regardless of which side hires me. They're commonly used, commonly researched in the field. Yeah, they're
Just one moment, please.
Sure.
Sorry.
Is it for the record?
a copy of the report I wrote in this case relating to Mr. Moreno.
And when was that report made?
It was last week. I wrote it on June 5th.
You mean July 5th?
July 5th. I'm sorry. July 5th.
No problem. And is this a fair and accurate depiction of the risk assessment report you completed for Mr. Moreno?
Yeah, it sure appears to be. Yes, ma'am.
All right. At this time, we offer into evidence defendant's exhibit 2, the sex offender risk assessment report of Dr. Stephen Thorne.
Wait, again, objects on Thursday, Your Honor.
All right, that objection will be overruled. Defense exhibit number 2 is admitted. All right, you may proceed, counsel.
And so if you could be a little more specific, I know you provided some general details. What methods and principles did you employ in this specific risk assessment?
Well, I performed a clinical interview of Mr. Moreno. I reviewed records relating to the current offense, both the indictment, the offense report, some letters and notes relating to the offense. And then I administered various, psychological or actuarial measures, the adult self-assessment inventory, the MMPI-2 RF, the personal problems checklist for adults, the static 99R, and the RSVP.
And so you had mentioned factors that decrease or increase the likelihood of committing a sex offense in the future. Could you specifically outline what factors were examined with respect to Mr. Moreno?
Well, when looking at, again, what we call like risk factors or protective factors, and looking at some of the risk factors, he has a conviction for a sex offense or for sex offenses committed against, minor children. So that, the age of the age of the victim is important, as, that's thought to be a risk factor. He does have a history of non-sexual criminal behavior. And as we referenced earlier, like antisocial traits is a particular risk factor in these types of cases. So his history of non-sexual criminal offenses is relevant to consider as well.
No, I don't want to interrupt, but I did hear you mention something about sexual offenses against children. Just to be clear, were there any, upon reviewing the history of Marco Moreno, were there any past indicators of a criminal history regarding sex offenses against children, aside from this instant case?
Yeah, not prior to this case. So when I was talking about he has a, relating to a conviction in this case for having an underage female victim, but no prior, so no prior sexual offenses.
And so based on your overall assessment, what is your professional opinion, your professional and expert opinion regarding Mr. Moreno's risk?
Well, I should say, I think you'd asked me about factors I considered. I only got to the protective factors, or only got to the risk factors. I did not get to the protective factors, if you want me to address those as well.
Sure.
Okay. The protective factors are he doesn't have any previous convictions for a sex offense. Sex offenders who have a single sentencing occasion for a sex offense are thought to have lower levels of recidivism than those who have multiple sentencing occasions for a sex offense. He doesn't have any male victims. He doesn't have any stranger victims. He doesn't have any victims outside of his family, or any documented victims, I should say. He doesn't appear to have a history of significant psychiatric issues that might increase his risk for sexual deviancy. He seems to at times have had a history of social support and had a history of ability to maintain employment. So those are some of the protective factors that we look at in these types of cases. And then his age. He's currently in an age group where at that age, we expect to see, statistically speaking, we expect to see lower levels of sexual recidivism. So those are some of the protective factors.
And so taking all of these factors into account, what is your assessment regarding Mr. Moreno's risk?
Yeah, I would say he's a relatively low risk for sexual recidivism. And, that's kind of supported again by the protective factors and the risk factors, but also the scoring of the static 99R and the RSVP. So again, my overall opinion is he's presently a low risk for sexual recidivism.
And so regarding the possibility of deferred adjudication community supervision, are you in a position to recommend any kinds of conditions that may be helpful to Mr. Moreno?
And Your Honor, I just would object that this is outside of his scope. He was listed as an expert in sexual predator recidivism rates.
All right, that'll be overruled. I'll let him answer.
I wouldn't have a lot of specific recommendations, about conditions of probation or supervision outside of, I do think sex offender treatment would be appropriate. I think research shows that individuals who successfully complete sex offender treatment, that can lower their risk for recidivism compared to those who are unable to complete a comprehensive sex offender treatment program. So my one, I guess, recommendation relating to that would be that he participate in and successfully complete, a comprehensive sex offender treatment program.
All right, no further questions. Thank you, Dr. Thorne.
Any
Yes, ma'am.
questions?
Briefly, Your Honor. Good afternoon, Dr. Thorne. Can you hear me okay?
I can hear you, but I can't see you, but I can hear you. Yes, ma'am.
Okay, well, my name's Ashley Jones. I'm the prosecutor in this case, and I just had a couple questions regarding to the risk factors that you use to give
Sure.
your opinion.
Yes, ma'am.
It seems that a multitude of them are reliant upon Mr. Moreno's self-disclosure. Would you agree with me on that?
I would, not all. I mean, some are confirmed by the records, but yes, I would agree that some of that is dependent upon his self-report.
Right, and so you would agree with me that Mr. Moreno likely wouldn't admit to any other sexual offenses if there were any other sexual offenses, right?
I don't know that I would use the term likely. I'm not trying to quibble with you. Some people do, some people don't, but I can say I'm not surprised if people don't admit to any undocumented victims. So I hope that makes sense.
It does, thank you. And as a psychologist, you would know that it's hard for kids to speak out about sexual violations that have occurred to them.
Sure. Yes, ma'am.
And so, and I think you mentioned earlier in your testimony that there are no other documented victims, but you're not saying there aren't any other victims out there.
Right. And that's exactly why I try to use that term, documented victims, documented by arrest or conviction. Because sometimes people have victims that don't result in arrest or conviction. So I try to use that specific language for that reason.
And I do believe in your report, you stated that no one factor can accurately predict whether a defendant will commit another sexual offense. Is that correct?
Yes, ma'am. Yes, ma'am.
And so you're not saying that Mr. Moreno wouldn't commit another sexual offense. You're just saying based off his self-disclosures and what you've read, the risk is low.
Yeah, first of all, I would never say that about anybody, that they will or won't commit a sex offense in the future. But yeah, my opinion about low risk is based off, again, not just his self-report, but also information in the offense report, what he's convicted of, and probably most importantly, an application of the research to his particular case. So
yeah, and just going to the procedures used in evaluation, it was a clinical interview with him.
Yes, ma'am.
Okay, an adult assessment, self-assessment, so one that he did, right?
Yes, he kind of checked yes or no to a number of items on that measure.
And then there was this Minnesota multiphasic personality inventory number 2. And I do believe in your report you stated his test results should be interpreted with caution. Is that correct?
Right, correct.
And that would be because there's history of underreporting when the self is underreporting in that test. Is that correct?
Yeah, on that particular test, it wasn't invalid. It wasn't to the point it was invalid, but it did suggest maybe a reluctance to admit certain shortcomings, weaknesses, problem areas. So that's why I qualified that in the report.
And then the personal problems checklist for adults, that was also completed by Mr. Moreno.
Yes, ma'am.
No further questions, Your Honor.
All right, any other questions?
No further questions for this witness. May he be excused?
Yes, thank you so much for coming, Dr. Thorne.
Thank you, Your Honor. I appreciate it.
Okay.
Yeah, we're trying to locate them, so.
Because I had them yesterday. I had the files. They should be physical files.
Hello.
Morning.
Morning. A day without Odyssey. Is it a joy? I don't know. We shall see.
I thought it was just me this morning. I didn't realize it was everybody's.
Oh, no, everybody. And I don't believe there's a backup plan.
Why would we plan for that, right? That goes against everything we stand for.
And whenever I bring up backup plans, because I'm always thinking you should think of worst case scenarios, right? My questions were never answered. Like, what's the backup plan? You're making more room because all the files will be gone. But if Odyssey fails, what's the backup plan? And guess what? There's no backup plan.
There is none.
No. So, Mr. Cavazos, just be patient with us. We're trying to see if there's a physical file.
Yes, ma'am.
There may be a physical file, there may not be. But what are we here for today?
Judge, there were a couple things. One, Mr. Cavazos has filed an amendment to Mr. Rodriguez's bond. It was something, essentially it involves, previously, Mr. Rodriguez was unable to see his child without supervision.
Okay, I remember you all discussing this with me.
Yes, ma'am. And the state did look into it. I did talk to the mother of the child. We have no concerns about amending that condition. I think you would ask Mr. Cavazos to get the CPS order as well as maybe some other
Yes.
paperwork, which I believe he has applied to. So the order then was given to the court, but I believe you may have been in trial at the time.
Yeah.
So I think we had reset it till today for you to make a decision on.
And does
that.
he have a pretrial services officer or no?
I believe he does, but do you know, does he have?
Eric, who's the individual that you report to?
I can get you the name on the phone.
Okay.
I haven't needed today.
Yes, who is the person?
I'm gonna get the name, man.
All right.
She's loading.
Technology. It's all over. So,
Oh, it is.
How often do you report, Eric? Can you answer that?
Once a month. I have to report today.
There's two.
All right, thank you.
I mean, yeah.
Officer Mendez, Officer Mendez,
I'm sorry, who?
Officer Mendez.
Let me see. What's the first name?
It doesn't show, it just says Officer Mendez, pretrial services.
Would it be Celeste Mendez?
Or no.
Let me try. Maybe it's, but it also could be Roman.
Do you have a phone number or an email for them, Eric?
It's a 188 number. I don't think it's gonna work. Call it.
No, it shouldn't be an 8 number.
Or I get a text every, or a text, a reminder every month.
All right, well, do me a favor, text them and tell them that the judge wants to speak to them.
This one here.
All right, we're going to go on the record. Court is calling 2021 CR 0735 State versus Eric Rodriguez. Can I have parties announced for the record?
Stephen Spear for the state.
Jaime Cavazos for Mr. Rodriguez. There is another case also, Judge, on your docket for Mr. Rodriguez.
Yes,
And
I'm sorry. And also 2021 CR 0699.
Correct.
And are you Mr. Eric Rodriguez?
Yes, ma'am.
All right, so we're here for, the first thing we're here for, it's in regards to having contact with your son, is that correct?
Yes, Your Honor.
All right, and your counsel in the state did discuss with the court what the issues were. The court wanted certain items given to the court before I make a decision on whether or not to grant the defense's motion. My understanding is that the state, you're in agreement with the defense's motion?
That is correct. We have no objection to
All
the
right.
motion.
So the court wanted proof that the Child Protective Services case was closed, or there was no concern from the worker defense. Our systems are down. You're an officer of the court. Can you tell the court, do you have that information?
Yes, Your Honor. I believe I'd actually forwarded to Your Honor via email. And in addition to that, a statement from the biological mother of the involved child, wherein she expressed to the court that she had no concerns or reservations with Mr. Rodriguez being unsupervised with her child.
All right, and have the visits been supervised prior to this?
Yes, Your Honor, they have.
All right, and how old is the child?
Eric, can you help us with that?
He's 12 right now.
He's 12?
Yes, ma'am.
All right, so I believe and there's some sort of child custody arrangement?
That I'm not 100% sure. That's my understanding, but perhaps defense or Mr. Rodriguez could speak to that.
All right, defense, is there a child custody arrangement?
Mr. Rodriguez, could you answer that question? Is there a court
You want to
court
raise your
order?
right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Eric Rodriguez.
All right, is there some sort of custody agreement, legal custody agreement between you and the child's mother?
Yes, ma'am. We have joint custody. I get them every other week.
Every other week?
Yes, ma'am.
And can you tell me, was the custody arrangement in place before or after the alleged incident that you're here for?
It was, before the incident.
All right, so after the alleged incident, were there changes in the custody agreement?
No, ma'am.
All right, but there was Child Protective Services involved?
Yes, ma'am.
All right. And Child Protective Services, did they have you do some sort of service plan or no?
No, ma'am.
All right. But did they interview you? What did Child Protective Services do?
Yes, ma'am. They interviewed me, my child, my family, and, it was closed the next day.
All right.
Your Honor, I believe Child Protective Services made the decision to close the file back in 2021. I don't know the exact date, but it occurred very early on. And there was no motions to modify the court order possession order by the mother because she had no concerns.
All right. Well, I will tell you this, if you all will write an order, the court then will sign the order and grant it. There are no orders attached to your motion for some reason. I believe that's another Odyssey glitch.
Well, Your Honor, I believe we had the order in back offices but I just don't know where the order actually ended up.
They are-
Because it was before the file actually made it to the court.
They're somewhere in Odyssey.
Oh, okay.
We'll regenerate an order, Judge.
Oh, yes.
with
And I don't need the entire motion, just an order. And if you can send it to me and you can send it to my email
Okay.
and well, actually send it to the coordinator's email.
Will do.
I'll put it in the chat. There's no dot in your email, is there? All right. Okay. Now, then the next thing we need to take up is the motion for continuance.
Yes, Your Honor.
Yes.
This case went first to the trial court, obviously, the 226 then, and a motion to suppress was granted. The state appealed that decision to the fourth court, which affirmed. There was 4 issues that were before the fourth court of appeals. And the decision was to affirm the trial court's ruling. The state appealed the fourth court's decision to the Court of Criminal Appeals. And the Court of Criminal Appeals dealt with one issue and one issue only, and specifically said in its ruling that it left the other issues undecided. To be, or basically they didn't deal with them at any way. And for whatever reason, the Court of Criminal Appeals in its order indicated that the file should be sent to the trial court rather than the fourth court of appeals to deal with the remaining issues. Defense counsel that's handling the appeal out of Austin, Mr. Schulman, filed a motion for reconsideration and for clarity as to where the Court of Criminal Appeals is directing the file to be sent to. And there's been no decision on that motion as of today.
All right. And when was that motion filed with the fourth court? If you know, approximately.
With the fourth court or the decision?
I'm sorry, the Court of Criminal Appeals.
I believe that was. I'm looking it up on my computer, Judge. Give me 1 second.
No problem.
Okay. Looks like May 15th, Judge.
Okay.
The decision was delivered on May 14th of 2025, and I received a copy of that through defense or appellate counsel on May 15th of 2025.
And what is his request from the fourth court, please? For clarification?
No, the motion for reconsideration was filed with the Court of Criminal Appeals.
Oh, so he's filed a motion to
For
reconsider?
Exactly, yes. And for clarification on the directive or the mandate as to where the case is to be sent to for further action.
All right, this is what we're gonna do. Ms. Ferguson, on this case, if you can give them a 60-day reset. And I won't, even though our work is being graded on how we move cases, I'm not gonna charge either of you with the continuance use, because I know that one, your client does need clarification. And if there's a request from clarification from the higher courts, then that needs to be done before this case really moves on. So 60-day reset, please. All right, so we'll be back on September 11th. And while this case is working its way through the system, if you all can make sure that all discovery is completed.
Of course.
All right,
Yes,
is there anything else, counsel?
No, Your Honor, I'll work on that order and send it to Mr. Spear for review and signature that he's agreeable with the language, and we'll forward it to your clerk.
All right, thank you.
Thank you.
You can put it as a discovery.
Are we
All right,
excused, Judge?
you're excused. Once you sign the reset form, you will be excused. Thank you for dressing appropriately for court.
Yes, ma'am, thank you.
Thank you. Thank you, Mr. Cavazos.
Thank you, ma'am.
Thank you for hearing us.
Yes,
Yes, sir.
okay. All right, who's on here on Anthony Jacob Herrera? Hi. And counsel, do you have witnesses?
No, Your Honor.
All right. Court is calling 2025 CR 0000069, State versus Xavier Chamberlain. Could I have parties announced?
Rick Payne for the state of Texas.
Renee Munoz on behalf of Mr. Chamberlain.
And are you Mr. Chamberlain?
Good morning, Your Honor. Yes, ma'am.
All right, according to the plea bargain agreement, just one second, we'll wait till they're finished over here. All right, you entered a plea on May 27th of no contest to assault a family household member with a previous conviction. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. This is to run concurrent with 2025 CR 0000071, 2025 CR 0000092. Those cause numbers, have you been sentenced on those, or those motions to revoke?
They're all new cases that got indicted. He doesn't have any pending motions to revoke. It's just there was a plea on as to some and then summary BTIC to resolve.
All right. All right, have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections?
No objection by the defense.
No, well, I'm silent, but I'd just like to speak.
All right. All right, do you have any witnesses?
No, Your Honor, I believe procedural background justification as to what we believe is an appropriate course of action that we would ask the court to follow.
All right,
as
just
well
one
as-
second. State, any witnesses?
None from the state.
All right, then you may proceed.
Thank you, Your Honor. In reference to Mr. Chamberlain, I have been on his case ever since he got picked up on these offenses in October. I've met with him routinely. And this is an individual that I believe is grappling with drug addiction and does not have an innate sense of criminality, Your Honor. Ever since he's been in pending custody in the Bexar County Jail, he has done family violence individual counseling. I have those forms here, if I may show the court.
Any objection?
None from the state.
And so he has been working on those things. He has been learning about boundaries and effective ways to deal with stressors in his life as well, to not take him out in a violent way, Judge. There's some cases pending here, but if the court does take note, one of the offenses, there was no bodily injuries observed by law enforcement, and the other one, there was a small, slight little scratch. In dealing with the case and talking about the evidence and our avenues for taking this in front of the court in terms of sentencing, we did talk about certain inconsistencies within some of the reports, but that was more so before he accepted the plea. So he does accept responsibility. He knows that he messed up. He knows that this was a toxic relationship with an ex that he shouldn't have been continuing, but he was in the midst of drug addiction. As noted in the PSI, he was under the influence of drugs at the time of these offenses, Judge. Also in the PSI, he has never had residential treatments. He has had outpatient treatment before, but because we believe that his needs are severe in terms of his daily methamphetamine usage before he got picked up, we feel like inpatient treatment would be more so suitable for him to get a grasp on his issues that he's dealing with. We're looking, Your Honor, in terms of his whole life and his future down the road. And in terms of serving the community and also helping Mr. Chamberlain work towards bettering himself, we feel that inpatient treatment would be more conducive in that we're able to address the root cause of this and hopefully put a stop to this from ever occurring again. If Mr. Chamberlain is institutionalized or incarcerated without the proper form of treatment, we feel that we may just be repeating this pattern of events that has been going on. Mr. Chamberlain has been to prison before, Your Honor, but this was about 20 years ago. When he was younger, did not get the appropriate treatment. He was essentially sent to TDC, released out, and had been battling homelessness as well as drug abuse. For these reasons, Your Honor, we're requesting a period of a deferred adjudication as long as the court sees fit with inpatient treatments. And I did speak about if the court did approve inpatient treatment, what that would be looking like in terms of transfer to a facility and then having to be compliant with the terms of community supervision thereafter. Before Mr. Chamberlain was picked up on this offense, he did start school at St. Philip's College. He was about 1 month into that program until he got picked up on this offense and did not have the opportunity to bond out. But he had been working towards his HVAC certification, where he wanted to work in that capacity in terms of a career for himself, Judge. So in looking at his criminal history, he does have minor things such as theft, drug possession, burglary. These are all things that I think were tied with drug addiction, drug usage. So we're asking that the court take a look to see if he's eligible to address the root cause of that addiction to stop this cycle of institutionalization.
All right. Is there anything you wish to say, sir?
Yes, ma'am.
You want to raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Xavier Chamberlain.
All right, you may proceed. What would you like to say?
Your Honor, I take full accountability for my actions and I'm very remorseful, but at the same time, I know that I learned a lot from this experience. I'm not the same person I was a year ago. I just want to move forward in my life and just be a better person for my family, for members of my community, and just get past this and just move forward. I'm too old to be making mistakes and
But the question is, why do you, I mean, these are not mistakes, these are choices. Why do you keep making the same choices? Because you have previous convictions for assaultive behavior. That's why this is a assault with a second conviction. So why do you keep making these same decisions? And then we have the violation of protective order. So there's a protective order in place. And when people violate protective orders, those are court orders. So that tells the court, if you're violating that, then you won't follow my orders because you're already violating a court's order.
I was under the influence of drugs and
I'm sorry, what?
I was under the influence of narcotics, Your Honor, and I'm just trying to seek opportunity for treatment.
But I mean, yeah, you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant and striking the complainant.
I was living there, Your Honor.
But wasn't there a protective order for you not to be at that location?
Not to my knowledge, and not until I was arrested was I informed of the protective order. My ex never told me about it.
Okay. All right, is there anything else? And on this case, what I can tell you, I don't have the trial court certification of defendant's rights to appeal. I know you probably filed it, but it's lost somewhere. So if you could do another one for me, please.
Yes, Judge, would that be one I have to get from them, or do they have them on? The
They
wall?
should have them on the wall now.
Yes.
He took the last one.
Oh.
The clerks
Yeah,
may
you
have
quick.
some more. All right, the cause number is 2025 CR 00069.
Things go like hotcakes, Your Honor, these nice ones.
Oh, yeah.
They're custard. They repeat this, and this is just a formality of the. What's the honor committee tender it?
Yes, thank you. All right, any further witnesses?
None from the state.
None from the defense, Your Honor.
All right, so Mr. Chamberlain, I want you to know your attorney did a very good job for you because you have numerous cases that are open and pending, right?
That's right.
I just don't think that you're a good candidate for probation. So I'm going to find you guilty. There's an affirmative finding of family violence. There's to be no contact with the complainant. A $1,500 fine, time and money to run concurrently. This will run concurrent with 2025 CR 00071, 2025 CR 00092. Take in consideration 2025 CR 00070, 2025 AL 002118. Court will give you credit for any time served, the therapeutic community, and 5 years in the prison. With the therapeutic community, I have no jurisdiction to mandate that you be in the program, but they'll know in the judgment that I'm requesting the therapeutic community for you. So there may be either mental health issues or drug issues. You're still going to have to request the program. You understand? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
That's right.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
That's right.
All right, we can go off the record. So here's the thing. When you are released from the prison, if you can't find a place that can help you with your addictions, you can always come back to here. If I'm here, then I will see if we can find a placement for you, okay?
Thank you.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. And if y'all can see what's going to happen with the remaining cases, please.
Yes, Your Honor, I'll definitely check up on that.
All right, thank you. The court is calling Joseph Joshua Harris. Where are you?
Good morning.
Good morning. So where are we on discovery?
Judge, it's something that I might have, well, I want to bring up to the court.
And we will see what we're going to do, okay?
Okay.
All right, so Ms. Ferguson, on this case, can I get a 30-day reset? And we may end up bringing you back sooner than this, but this is just to give the court more time and the state and your counsel more time to confer with each other.
Okay.
Yes, ma'am.
All right, so we'll be back on August 14th. All right, thank you.
Thank you.
Who's here on Johnny Galvan?
Here for Mr. Garcia.
Yes. And Mr. Galvan? Come down, please. How's he doing?
He went to see the doctor who is now referring him to other doctors.
Let me ask you this. Who's appointed on these cases? Would you like to be appointed on these since?
If that's fine, Judge, if that helps you, that's.
Well,
not-
I mean, so that his client.
For this particular, but the other who's up there as well, Pedro Rodriguez, he's hired, so he's hired on that one. Yeah.
All right, and this one is appointed, correct?
Correct.
All right, Norma, on this case, could you put Ms. Christian down as co-counsel?
Perfect.
All right, so what I'm gonna do, your attorney is ill, right? So I'm gonna recall this for discovery, so this attorney can get up to speed on everything.
Yes, ma'am.
All right, Norma, if I can have 3 weeks on each of these, please.
think on Mr. Rodriguez's case, he just wanted it set for trial. But
All right,
however
well,
you want to
we'll-
do it. August 5th.
All right, it's gonna be August fifth. State on Johnny Galvin on August fifth. You'll need to be prepared to tender an offer.
Yes, Judge.
All right, Mr. Galvin, I see you're a Padres fan. All right, so they're gonna take you back unless you have anything else to discuss.
No, and then I'll check out that discovery and I'll make something happen. August
All right.
5th.
All right, sir, you can have a seat back in the box. And then who's the other person?
The other one is Pedro Rodriguez.
All right, Pedro Rodriguez. Where's your client? Oh, he needs to come up.
He's coming.
Yeah, no, he's just sitting there. People, sometimes they don't want to be a part of their own case. I'm like, come forward.
Good morning, Your Honor.
Good morning. All right, state, were you able to tender an offer?
Judge, so I previously came before this court and erroneously said that discovery was complete, and conferring with Mr. Arglios and reviewing the case myself. This case was done in conjunction with some federal officers, and it looks like some of the federal discovery is missing, and so I need to draft a treaty letter to obtain that evidence.
All right, and how much time do you need?
Judge, I would request 30 days.
All right. All right, I need a 30-day reset on Anthony Herrera, please.
Thank you. Thank you, Judge.
No, you need to know what your day is.
Oh, no,
Do you want to know?
no.
Maybe you don't want to know.
Hopefully, okay.
I can do that August 19th.
All right, it's August 19th. Just have a seat and they'll give you a reset form and then you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
It's on.
Thursday over the afternoon, so I can hold on to it.
Go back and after.
Yes.
That's no problem.
Is he in jail?
No, no, no.
Is he here?
And Norma? Christine, her client. Do you know if we have a file for him? All right, thank you. All right, who's here on Zachary Gilmore?
There's a motion for early termination. I have to ask for a reset.
Okay,
Last 30th, which is next Wednesday for the following Wednesday.
all right, Norma, are we able to recall this for? Yeah,
You can be my only stop that morning. I can come here first.
all right. And we already have something on July 30th? All right, we'll put you on July 30th
Okay.
and we'll take this up first.
It's not next Wednesday, but the following Wednesday.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Thank you.
Thanks, Judge.
You're welcome. All right, David Escobedo. And counsel, hi, are you retained?
I am not, Judge.
You're appointed?
I am.
All right, Mr. Escobedo, is the court's understanding, based upon the council's motion to the withdrawal, you want to hire an attorney? All right, you have 2 weeks to get an attorney. If not, this will be your attorney. And you can speak to him or not speak to him. That's completely up to you. If you go to trial, you will go to a trial with an attorney you have not spoken to. But he's been your attorney since April. So 2 weeks, you need to have your new attorney here if you're planning on hiring one. Ms. Ferguson, I need a 2-week reset.
July 29th.
And state
Yes.
and defense, do you have all of the discovery?
Yes, Judge.
All right, if you can do an acknowledgement of discovery for me, the system's down.
It is.
So it's down. Were you able to tender an offer?
Not today, but I can get one.
All right. All right, so if you'll tender an offer today and July 30th, I'm sorry, July 29th will also be your plea deadline date. All right, once you sign the reset form, you're excused.
Okay.
All right, and they will give you an offer, counsel. Yes. And Mr. Escobedo, you need to be on time for court next time. Do you understand? All right, let me just tell you, the other courtroom you were in, was it a district court? All right. Sylvia Noriega. Who's the attorney for Sylvia Noriega? All right, why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level, so don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take them?
Yeah. All right, I don't understand. Why are people winking at me? We're not on that level. All right, Sylvia Noriega? Yes.
This was a motion to adjudicate things we sent a couple of weeks ago.
Mhm.
We said it to see if any of the restitution had gone to the alleged victim.
Yes.
And that's where we are now. She's been on deferred, I believe, for about 10 years.
So were you able to pay any restitution?
Well, I haven't paid any money yet because I was waiting to see what was gonna happen.
You have a motion to revoke because you haven't paid any restitution. What's going to happen is if you don't pay restitution, and it appears based upon what you've told me that you have money to pay restitution, but you're trying to see what's going to happen and hedge your bets. So we can go forward on the motion. Do you want to go forward on the motion to revoke today, counsel?
No, Judge, I think the issue is she's paid restitution, but we don't know regarding the probation, if all the restitution has gone to the alleged victim or if it's going to probation. I think that's what the issue was the last time we were in court. to figure it
Right.
out. Unfortunately, today, because the system is down, probation's unable to look at information.
Are you able to come back this afternoon?
What time?
We can have her back at 1:30 and we can see if the systems are up.
Would I be able to do it by Zoom or would you?
Yes, you can do it by Zoom. Well, you know what, let's not say 1:30 because we have trial that starts at 1:30. I tell you what, we'll recall it for tomorrow and for restitution issues. And if your client wants to appear by Zoom, she can appear by Zoom because it's a matter of restitution. And then if there's an issue, we can always reset it for a contested MTR if that's what needs to be done. All right?
Yes, ma'am. Thank you.
All right, so make sure though that you save some money in case they say that you owe restitution, okay?
Yes, ma'am.
All right, do you have any questions about anything? Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you're excused. Okay. And transferred where?
To 227. It's Cody Plain's case is there.
All right. Thank you. And just let Deputy Laura know.
Thanks, Judge.
You're welcome. All right, who's here on David Wayne Huff?
I have her. We're ready with an MTR with the agreement.
Okay.
Are you ready for it, Judge?
Yes.
I think that's it.
Oh, Wacon Fields, they say they're being transferred to the 227. And it's on page 6. Sure. Bye.
Good morning.
So are they seeking to withdraw this?
No, Your Honor, we're going to plead true with an agreement to continue on probation. With the evaluations to be done in custody.
And is this a misdemeanor assault?
It is a non-family misdemeanor assault, Your Honor. And there's already an agreement in place. I'm not the lawyer on that case, but there's an agreement to dispose of that case.
And what's the agreement on that case?
90 days to do. He will have probably racked up enough time by the time he's in custody. Getting done his obligation.
All right, so you understand, if you have an agreement with the state of defense, I don't have to follow that agreement. You understand that? All right. Court is calling 2025 CR 003649 State versus David Wayne Huff. Can I have parties announced?
Deputy Clerk of the State of Texas, Your Honor.
Matthew Finch for David Huff, Your Honor, ready?
And are you Mr. Huff?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right. Are you the same David Wayne Huff who was placed on community supervision in 2025 CR 003649 for the offense of possession of a controlled substance, penalty group 1B NA? It's in a drug-free zone on May 15, 2025 for a term of 6 years. All right, state.
Violation of condition number 1, on or about the 16th day of May, 2025 in Bear County, Texas, the defendant, David Wayne Huff, committed the offense of assault in violation of condition number 1.
All right, and how do you plead?
Sure.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to continue probationer on probation, but to allow for all the evaluations that have not yet been complete to be completed while in custody. The state understands that there is a proposed agreement as to what will happen with the assault that defendant has just pledged true to. So continuing probation will have everything, all the cases will be taken care of, and the state believes that probationer will be able to start a successful probation journey. Your Honor.
All right, sure. And that's the agreement, counsel?
It is, Your Honor.
You want to raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record.
David Wayne Huff.
All right, so Mr. Huff, they're saying that they want certain evaluations done in custody. I see that you were placed on probation in May. So why did you not follow through with those evaluations out of custody?
I was only on probation 8 hours.
I'm sorry?
8 hours.
Yes, so what happened?
Okay,
So you 8 hours and then this incident is alleged to have occurred?
To maybe shortcut, Judge, he went home. There were some people living in his home that he was trying to get out of his home. An altercation happened. It was people that were trying to get him to use drugs, Judge. And he was trying to do the right thing. He told me this story and told several people that story, but he was trying to fix the problem so he could be successful, and here we are. And he's been in custody since.
Okay. It explains things.
Yes, ma'am.
Now I understand why I should follow your agreement. All right, this is what the court is going to do. The court, as previously stated, is finding violation of condition number 1 true. The court will alter and amend conditions to the following, and this is to happen in custody. A TAP evaluation and a referral to felony drug court. And I am going to order, I think somebody's already ordered you to have 120 sober meetings in 120 days. Was that previously ordered?
It was, Judge.
All right. So you're to make sure that you do that. If for some reason, because the systems are down, if some reason they release you from the Bear County Jail, you know you're not supposed to be released, right?
Yes, ma'am.
If for some reason they release you, don't fight them over it. Just come back to this court in the morning, okay?
Yes, ma'am.
All right, do you have any questions about anything?
No, ma'am, thank you.
All right, is there anything else you need from the court?
No, ma'am, I'll be successful.
All right, if in this court to be successful on probation, communication is key, right?
Yes, ma'am.
So if you need something, let probation know. If they feel like they're not addressing it, you can always come back to the court.
Yeah.
But whatever you do, don't do this thing where you don't report, okay?
Yeah.
All right, good luck to you.
Thank you.
Thank you, counsel.
Have a good evening.
Yes. All right, and Norma, when you get a chance, if you could have Mr. Castillon return. Thank you. Thank you. Baldemaro Chapa, who are you here for?
Mr. Chapa, who is not here, Your Honor.
Ah. All right, the court is going to call 2024 CR 009634, State versus Baldemaro Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
All right, this hearing was scheduled at 9 a.m. It is now 9:56 a.m. The defendant has not made an appearance. State.
The state would ask the court to issue a warrant.
All right, counsel, have you had any contact with Mr. Chapa?
Not this morning, and he has been communicative with me up until today.
All right, the court will grant the motion, remain your client without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
So if you want to see if you can get in touch with him before the day is out, just let the court know.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
All right, I'm going to take up Jesse Garcia. Then after that, it will be Marco Moreno. Thank you. Thank you for your patience. All right. Hi, who's here on Jesse Garcia? Hi, where's Mr. Garcia? Nobody wants to come forward anymore. How's it going? Yeah, I can't complain. System's down. Defendant weakening at me. I don't know what's going on. All right. So you are scheduled for a jury trial. We're currently in a jury trial. It may be completed today. So I'm going to recall you. Yes.
Case the victim didn't show up. I had deputy make an announcement, asking to confirm, and she can step in.
Okay. All right. And the court will note for the record that the court was tendered an affidavit of non-prosecution as well.
Yes.
And it is scheduled for jury trial today. All right, Mr. Garcia. All right, let me just tell you, they're dismissing this. They're saying that the complainant has waived prosecution. Whatever issues there are that are occurring, you need to make sure those are corrected, because otherwise you're going to be right back here. You understand?
I understand, Your Honor.
I will always tell people, if you get to a point in a relationship where you want to get violent with somebody or put your hands on someone and anything else than love, then maybe you shouldn't be in that relationship. You understand?
Thank you, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome. Thank you, counsel. Yes. All right. Marco Moreno. And state, on this case, do you have your file with the plea that you entered into? Do you have the plea page on this case? Yes.
Yes, Your
All right, if I could have a copy of that, please.
Honor, it's my personal copy. Odyssey is not working with me.
I'm sorry.
Odyssey is not working with me this morning.
Yeah, it's.
Judge, I have a hard copy. I can
Oh,
look at
yes, thank you.
it.
Okay, so Christine was ready for Odyssey to break down. Nobody else was ready. She was ready.
Well, I have a personal copy.
All right, what I'm gonna do with this case, your attorney is still counsel. I'm just gonna put this as August 5th as well, so maybe you can have an update for us.
I definitely will do that, Judge. But if you'd rather, he just asked me to set it for a trial setting, if that makes it more expeditious. Either way you want to do it.
Well, let's do an update.
Okay, got it.
On that date, and then after that, I'll do your trial set. Perfect. So on August 5th, we're gonna come back, for for this case with an update on counsel's health?
Okay, yes, Your Honor.
Because I don't want to set it for a jury trial date if he
Gotcha.
has
Yeah,
more time
other
than he's
issues.
gonna be
Okay.
out.
No worries.
Is that the same page?
Yes.
Yes.
And what page is he on?
He's on the first page.
Thank you.
And so keep it as a deadline.
Yes. All right, thank you.
Thank you, Judge.
Thank you, Judge.
You're welcome. All right, John Anthony Robles. And are these applications or none?
No, Judge.
Okay. Court is calling 2025 CR 006650, 2025 CR 006653, State versus John Anthony Robles. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
And Brandon Jackson for John Douglas.
And are you Mr. Robles?
Yes, Your Honor.
Counsel, have you received all discovery that you reviewed with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Robles, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, in the cause number ending in 50, are you proceeding on the indictment as presented?
No, Your Honor, the state is waiving and abandoning the repeat offender enhancement.
Any objection?
No objection, Your Honor.
And in the cause number ending in 53, are you proceeding on the indictment as presented?
No, Your Honor, the state is also waiving and abandoning the repeat offender enhancement.
And no objection, Judge.
All right, Mr. Robles, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in each offense you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felonies? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering these pleas, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Robles, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. The state is waiving the enhancement paragraphs. There are no applications. The cases will run concurrently and there's to be no contact with the complainants. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There are none, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers States Exhibit 1 and all attachments in both cases respectively are on.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you agree the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there will be no live testimony. Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments and each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I just respectfully ask that you follow the agreement. He's ready to get on with his life. He said he's done with this type of life and ready to move forward.
All right. And the cause number ending in 5-3. The court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served. This is run concurrent with 2025 CR 006650. And there's to be no contact with target. And I'll request the therapeutic community. And the cause number ending in 50. The court, as previously stated, is finding you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 006653. There's to be no contact with China King Buffet. And I request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you continue doing what you're doing, only 1 or 2 things going to end up happening. You're going to end up spending the rest of your life in prison, or somebody may end up killing you because you're stealing. And this is Texas. Okay? All right, good luck to you, sir. All right, Jorge Jimenez. Who's the person for her? Is the attorney for Jorge Jimenez here? Okay. Mahmoud Al-Gadrab. The attorney for Mahmoud I'm sorry, sir, your attorney's not here.
Oh.
Mahmoud Al-Gadrab, who's the attorney? All right. Enrique Talamontes Segura.
Sure, present.
All right, if you'll come down, please.